Yes, please call the list.
But this is an arbitration appeal, my lord.
Yes,
Against
yes.
the order passed in section 34, my lord. My lord, primarily we are agreed with the fact, my lord. I'll just.
Your section 34 was dismissed.
My lord, only one claim was set aside, my lord. Our case was that the entire arbitration award is without any reasoning, my lord, and it appears that the learned arbitrator has done some kind of charity to them, openly, my lord. Okay, you claim 20 lakh, you take 15 lakh, without any calculation, without any basis,
But we have to hear out the appeal
my lord.
and how much you have deposited.
My lord, we have deposited 50% before the trial court, my lord. I've annexed that, subject to outcome of.
Madam, have you preferred a cross objection?
Yes, Lordship. 45 lakhs. 45 lakhs.
45 lakh, 25,000 is deposited in the
One
court.
head of the award has been set aside.
No, 2 heads, Lordship.
Two heads
Okay,
have
2
set
heads. So are you filing a cross objection to this appeal against that part of the judgment?
Lordship, since time was very short for me, I just prepared an argument. If Lordship allows me, I can convert that into an affidavit in opposition.
Not
file.
affidavit. You either file a cross objection or a independent appeal.
Lordship.
Because you are aggrieved by that part of the award,
Lordship.
that part of the impugned judgment and order.
Lordship.
But at this point of time, what is the awarded amount?
My lord, originally it was 90 lakh rupees, my lord. That has been reduced by 25 and 126 lakh rupees, my lord. So it's 74, 75 lakh rupees.
No, but the original awarded amount has to be deposited.
Yes,
How much has been deposited with the trial court?
50% of the original awarded amount, my lord. 90 lakh was the award, 45 lakh we have deposited before the court below, my lord.
So another 45 you deposit.
No, my lord, at this stage the amount has been reduced as it is by the trial court, my lord.
No, but when there is an appeal from a setting aside application,
My lord.
the entire awarded amount has to be secured.
50% has already been deposited in the court below, my lord. Because they filed, they
Cash-
filed, they filed
cash
execution
deposit or
petition.
bank guarantee?
Check.
It is by check, my lord.
In favor of?
In favor of the party, my lord. You collected the amount?
Claimant, yes.
They have collected the amount?
Yes, Lordship.
They have collected the amount, my
Yes.
lord.
You've taken the amount.
Lordship.
By giving some bond, my lord.
Lordship, that was done in Tenga, Arunachal Pradesh.
What?
Arunachal Pradesh, the office is there, so they issued everything.
No, what counter guarantee you have furnished?
Some guarantee, Lordship, there I was not there. I had just collected.
No, that is very important.
Some bank guarantee was submitted with the department.
No, that does not. My lord, kindly comes to page 222, my lord. Along with an application, we deposited the check before the court, my lord,
Before the court.
in the execution petition.
Yes.
Page 222, lord, so kindly sees, my lord. Two 22.
222.
My lord. By this application, an application for bringing on record a check number so and so issued in favor of so and so, the same being 50% of the award dated so and so.
What was the order passed?
On this application,
Yes.
but I'll need the instruction. But the money has been released to them by the court upon giving a guarantee, my lord. Some kind of security has been taken by court and money has been
What
released.
kind of security? Bond is no security. Bond is a piece of paper.
But I can file an additional affidavit, my lord. What happened actually, my lord.
Is there any delay in preparing the appeal?
No. There's no delay.
We formally admit this appeal under Section 37 of the Arbitration and Conciliation Act, 1996. Where is the impugned judgment?
Starts at 225, my lord. 227, in fact.
It is from the impugned judgment and order dated 13th May 2025. Made by the learned court of the judge, Commercial Court, East Khasi Hills, Shillong, on 13th May 2025. The award except that in respect of claims 7 and 8 was upheld. The award in respect of claims 7 and 8 was set aside. Please read out this file. No, you add there in an application under Section 34 of the said Act made by the Union of India. Then continuation. The respondent contractor, the Union of India has preferred this appeal paragraph, we learned that during the pendency of the Section 34 application, the appellant had secured the awarded amount .50%.
50% of the
50% of the award.
initial award amount.
That is 45 lakhs.
45 lakhs, 25,000.
As no, you spell that out. The awarded amount was about rupees 90 lakhs. Full stop. We learned that during pendency of the Section 34 proceedings, the appellant had secured 50% of the said amount by furnishing a check of a little over rupees 45 lakhs. Full stop. Surprisingly, the check was issued in favor of the respondent contractor, when it ought to have been issued in favor of a competent officer of the court to be kept in deposit pending decision in the said application. You have encashed the money.
Yes, Lordship. 2017 itself.
This amount has been encashed. By the respondent.
Two 2019.
90.
45 lakhs, 25,000. That is not written. 20.
Had it not been allowed to be appropriated by the award holder, we would have considered directing the appellant to deposit the balance 50% sum pending hearing of the appeal as security in terms of the said act. Full stop. However, in view of the above, we do not find any necessity of directing the appellant to furnish any further security in the matter. Full stop. Our only concern is that should the appellant be successful in the appeal, how easily they would be able to realize the awarded amount already made over to the respondent contractor. Paragraph. Usual thing, since the respondent is represented, we expedite hearing of the appeal. Informal paper book. September 22nd. List on 6th October.
Number 2 and 22nd.
Dip.
May please Lordships.
Yes.
Lordship, here I am appearing on behalf of the union. The conducting council is from Guwahati, Your Lordship.
Sorry?
It seems the conducting council is from Guwahati, Your Lordship. This is a Union of India matter, Your Lordship. And I'm appearing on behalf of them. It seems today they cannot appear through the VC, Your Lordship. They were unable to get the VC link, Your Lordship.
What is this matter about? You know anything?
The conducting council is actually from Guwahati, Your Lordship. I humbly pray that the matter, if it can be listed in 22nd, Your Lordship.
But I'll be appearing for the respondents, but if I can be served with a copy of the...
What is this matter about? You don't know.
No, my lord, this matters, they're challenging, they've filed this arbitration appeal, challenging the order of, interim order of the arbitrator, my lord. My lord, there's a commercial court, my lord, which has jurisdiction. This appeal
Section
is not,
9.
Yes, my lord. This is not maintainable, my lord. They have filed an appeal directly before the High Court, my lord.
Oh, it's a section 17,
17, my lord.
order.
Order passed by the arbitrator, my lord. Granting the release of the my lord, bank guarantee, my lord. When the work is already complete, undisputed. My lord.
So the appeal lies...
Before the court, my lord, commercial court. At Shillong, my lord.
Lordship,
Arbitration Act.
may please Lordship. Lordship, I humbly pray if the matter may be listed on 22nd.
Section 37. 37(2)(b).
You've considered section 37.
My apologies, Your Lordship. With regards to this matter, I'm not aware.
8934 before the appeal court. Subsection 2 shall lie to a court from an order under section 17. Court is again defined in section 2, principal civil court.
Commercial.
We'll give you leave to file it before the appropriate court.
Your Lordship, the conducting counsel will be in a much better place.
Conducting counsel, I'm hearing for the fourth time. You are the conducting counsel before the court now. When you are on your legs, you are the conducting counsel. Forget about conduction and convection. All right, well, let him argue the matter.
A copy may be supplied, not. A copy of the appeal may be supplied, not.
Yes. Learned counsel for the respondents raises a point of maintainability of this appeal. Full stop. Since it is an appeal from an order in exercise of jurisdiction of the learned arbitrator under section 17 of the Arbitration and Conciliation Act, the appeal under section 37 within bracket 2 lies before the court defined in section 2 within bracket 1 within bracket E of the said act, comma, it is submitted. Stop. Paragraph. At this stage, we do not admit the appeal. Full stop. On the prayer of learned counsel for the appellant that a senior would argue this matter, this appeal is adjourned till 22nd you want?
Yes, Your Lordship.
All right. 22nd August.
Highly obliged, Lordship.
Number 3.
What is this? MC is what? State, not delay. Yes, please.
Please, Lordship. This is the PIA, Lordship. It's a petitioner's social spirited social activist, Your Lordship. Now, what happened? The police, Meghalaya Police Act was passed in the year of 2010.
You
which was,
speak a little louder. Pull the mic towards yourself.
Lordship.
Mic. Yes.
This Act, Meghalaya Police Act 2010, was passed by the Meghalaya Legislative Assembly and was duly notified on 7 February 2011, Your Lordship. Now the relevant running section, I have enclosed the page 25, the relevant section, which I am aggrieved here before the court is 73, that page 57 of the petition, Lordship, page 57, section 3. Section 3, 1 and 2, my lord. There is a provision. May I read, Your Lordship? Section 3, subclause 1, it says that in addition to the
57.
73, page 57, my lord. Page
Yes.
57. Page 57, and below the line there is a police accountability for conduct, that is 73, clause
First,
1.
tell us what is your cause of action? What is your grievance?
The grievance is that there is a provision for appointment of the Police Accountability Commission. This, as per this section 73, clause 2. It says that the state level Police Accountability Commission herein to be called as Accountability Commission consisting of chairperson, member, and as such other staff as may be necessary to inquire into public complaint supported by sworn statement against the police personnel for serious misconduct and perform such other function as stipulated in this chapter. Now, my lord, the grievances of the petitioner here is that since the section is clearly saying there is a provision for appointment of state level police accountability commission, the purpose and the aim is to oversee and to see the public complaint against any misconduct, against the misconduct of the police personnel.
Yes.
Since the Act has been passed in the 2010, which has been already notified in the 2011 in February 7 February 2011, but the government of Meghalaya, they have not taken an initiative till to date. After a lapse of quite many years, they have not taken an initiative to appoint the state level police accountability commission, Your Lordship. Due to the absence of the state level accountability commission, the public at large, there is no forum to file any complaint or any sort of complaint against the misconduct of the police personnel. So this is the only for the interest of the public, because the act is very clearly mentioned. Since as of now, Your Lordship, as per this provision, there is no police accountability commission. So the petitioner one here is only coming before the court, bringing to the notice of the court only that since this act has to be acted upon, it is passed by the government of Meghalaya, Your Lordship. That is the only thing, because the section is very clear, Your Lordship. And the petitioner also has some occasion, he has filed some representation requesting the government, but there is no proper response from the government, Your Lordship. So that is the only thing, Your Lordship.
Yes, Mr.
Amit, this is your lordship. Lordship, kindly come to paragraph 12 and 13 at page 16 of the petition, your lordship.
Yes.
Lordship, these are the grievances of the petitioner, your lordship. In my humble and respectful submission, your lordship, these grievances of the writ petitioner, there are remedies, your lordship. The state does have a state human rights commission, your lordship. In case of there is a...
Maybe, but when you have enacted legislation, why will you not carry it out?
Lordship, because lordship, as I have submitted, your lordship, grievances of the writ petitioner, your lordship, is mostly against allegation of police abuses, violation of human rights. As I have submitted, your lordship, this can be well addressed also by the State Human Rights Commission, your lordship.
That will not do. Then why did you enact it?
I'll have instruction then, your lordship.
And it is fully in your control.
Lordship, yes. Lordship, going by section 73 at page 57 of the petition.
No, the committee creating the commission, it consists of Home Minister,
Lordship, kindly
Chief
come.
Secretary, Home Secretary,
Lordship, it's
DG.
that is the composition of the committee.
Selection Committee.
Lordship, yes. So
Yes.
far, your lordship, so far the state level police accountability commission, lordship, will find it at page 57, section 73, subsection 2, your lordship. Lordship, kindly see, your lordship, the state government shall within 3 months of the coming into force of this act establish a state level a state level police accountability commission, herein to be called a accountability commission consisting of a chairperson, members, and such other staff as may be necessary to inquire into public complaints, Your Lordship. This is only just an inquiry into public complaint, if there any public complaint, Your Lordship. As I have submitted, Your Lordship, this can be well addressed by the State Human Rights Commission, Your Lordship.
That will not do.
Your Lordship, then I'll have instruction, Your Lordship, in the matter whether that commission has been constituted or not, Your Lordship. Let me have instruction, Your Lordship, in the matter.
Do you have instructions whether it has been?
No, let me have, Your Lordship. I'll obtain instruction, Your Lordship, in the matter.
Just now you said Human Rights Commission is sufficient to look into this area.
Lordship, my submission is that if there is police abuses as claimed by the writ petitioner,
then if it was constituted, you would not have made this submission. So that means it has not been constituted. This
no,
committee.
Lordship. So far, the State Human Rights Commission, it is there, Your Lordship. The State Human Rights Commission is there. But so far, this this commission, Your Lordship.
Constitute the committee. If not done, do it. Finished.
Lordship, let me have instruction as to whether.
What instructions regarding what?
Lordship, I'll have instruction whether this accountability commission has been constituted or not, Your Lordship.
If it has been, very good.
Lordship, yes.
If it is, if it has not been, do it.
Lordship, yes.
All right,
Lordship.
This public interest litigation is meritorious. Full stop. It can be disposed of. At the threshold on the first day. Full stop. Under the Meghalaya Police Act 2010, the role of an ombudsman is conceived of to inquire into any allegations of misconduct by the police. Chapter Roman 12 deals with police accountability. Section 73 provides that in addition to departmental rules with regard to accountability, strict accountability was being ensured by the said Act through, within quotation, additional mechanisms detailed in this chapter, unquote. Additional to chapter. This section provides for constitution within 3 months of the coming into effect of the Act, a state-level police accountability commission to be called Accountability Commission. Paragraph. The principal grievance of the petitioner is that despite enactment of this legislation in 2010, this commission has not been constituted by the government. The composition of the Accountability Commission is provided in Section 74. Within bracket 1, whereas the selection committee, the selecting authority for this commission is mentioned in Section 74 within bracket 2 of the said Act as follows. Set out 74, 1 and 2. Mark portion, page 58. Paragraph. It appears that this Accountability Commission it appears that the role of this Accountability Commission is very holistic for the police force. Full stop. It is mainly advisory and providing views and guidance to the government and to the police department. Full stop. It has the power to inquire into the records of investigation done by the police with regard to any offence, and if it finds that the inquiry has not been made, with proper pace or with proper pace or with proper application of mind, it would direct the higher authorities to expedite the inquiry. Similarly, it would advise start of departmental proceedings in respect of any complaint against a police officer or expedition of such inquiry by the departmental, by the disciplinary authority in case it is unnecessarily kept pending. It also has general advisory power to advise lawful inquiry being made against legitimate complaints against legitimate complaints being made with regard to commission of offences or acts of misconduct by police officials. Full stop. This committee has conceived by the said act would be healthy for the administration, for the police administration of the state. Paragraph. To be accordingly direct the state government to constitute this commission in terms of the Meghalaya Police Act 2010 within 3 months from date. We also note the submission of Mr. Churai Lanin, Additional Advocate General, that there are other enactments in force in the state which take care of which provide for discharge of the functions of the commission which have been provided by this act.
Lords.
And that for this reason the said act was not implemented. Full stop. If that be the case, the state government would be at free to amend or repeal the act. Meghalaya Police Act 2010. Full stop. In case that is not done, the directions in our order have to be complied with.
Lordship only whether Lordship is giving the time frame.
3 months.
Let it be 6 months, Your Lordship, because there is a search committee, Your Lordship. That search committee will have to be constituted and application will have to be for Your Lordship. It will
6 months is a very long time. 4 months from date.
Let it be 5 months, Your Lordship.
4 months. 4 months. Enough. It is all mentioned who will be members of the
Lordship,
commission.
yes, that is correct.
What search you will make in this whole state? 4 months.
Apply, Your Lord.
As well as Lordship.
Yes.
Number 4.
Lordship,
Yes.
I'm praying, Lordship, if this matter can be taken up on 20th of August, Lordship. Learned Senior Mr. K. Paul is leading us in this matter, Lordship.
20th.
20th of this month, Lordship. Subject to Lordship's
That
continuance.
is tomorrow.
Lordship, 20th, day after, Lordship.
Day after tomorrow.
Wednesday.
All right. By consent of learned counsel for the parties, with this appeal and application are adjourn till 2-0.
Number 5.
Delay.
Ready for hearing?
My lord, this is a fresh matter, my lord.
Ready for hearing? Appeal or new appeal?
It's an appeal from the order of the learned single judge, my lord.
Appealing for the first time.
First time, my lord.
Delay involved.
No, there's no delay, my lord.
So what is this MC?
First stay, my lord.
Then serve.
We'll serve the respondents. There's only one respondent, my lord.
List this appeal and application. On 28 August. You'll be able to serve by then.
My lord.
Service is to be effected in the meantime. Service on the respondent is to be effected in the meantime. And an affidavit of service filed in court.
Deep.
Number 6.
Who's in number 6?
May I please, Your Lordship?
Yes.
Your Lordship, this is an appeal preferred against the...
Appealing for the first time?
Yes, Your Lordship.
First time?
In this court, yes, Your Lordship.
No, not this court. It is first time after institution.
Lordship, yes.
Yes, Your Lordship.
And there is a delay also, Lordship.
There's a delay of
1154 days, Your Lordship.
You have filed a petition for continuation of delay, Your Lordship.
How many days, Mr.
1154 days, Your Lordship.
Dismissed. What you will do?
Lordship, we have filed, Your Lordship. There is a merit in this case, Your Lordship.
What is the reason for the delay?
And if Lordship, kindly see the statement made
4,
in
5 and 6 in our continuation of delay of Lordship. We have mentioned this where there is a delay on the part of the appellant. Para 4, Your Lordship. May I kindly read?
What is the reason? You tell us.
Your Lordship, he was looking after his uncle, Your Lordship.
Huh?
His uncle. He was looking after his uncle, Your Lordship, who was suffering from severe kidney problems, Your Lordship. For 3 years, he was looking after him, and he has spent a substantial amount of money also, Your Lordship. And he has financial hardship also, Your Lordship. And he was the only male member of the family, Your Lordship, and he was looking after his uncle. Mentally, he was depressed also, Your Lordship, and financial hardship.
Ask him to enhance the microphone,
Yes, sir.
loudness. That's all.
Your Lordship, he was looking after his uncle, who was suffering from severe kidney problems, Your Lordship, for 3 years. And he has spent a substantial amount of money also, as he was only the male member of his family, Your Lordship. He was to take care of his uncle and other financial things
What
also.
is the order? What is the impugned order? Dismissal of the writ application.
Yes, unauthorized leave, Your Lordship. He was on unauthorized leave. It was alleged that he was on unauthorized leave, Your Lordship. Then we have preferred a writ petition, Your Lordship, and it was dismissed by order dated. Your Lordship, page number 14, Your Lordship.
You were dismissed from service.
Yes, Your Lordship.
Dismissed.
Yes, miss. Dismissal from service.
Then again, your writ was dismissed and you made a further delay of 1,000 days in
Your
preparing the
Lordship.
appeal.
Your Lordship, he was taking care of his uncle, Your Lordship.
Then let him take care.
Now he is no more, Your Lordship.
He lost his job.
He lost his job also, Your Lordship.
Thereafter, he did not wake up. To prefer an appeal also, he took 1,000 days, 3 years.
As he was,
Where he was working.
he was from the Meghalaya Police Department, Your Lordship. Meghalaya Police.
Where he was working? In Dubai?
No, Your Lordship.
Then
He was working in Shillong, Your Lordship.
find out where he was in 3 years.
Even Shillong, Your Lordship.
Lordship, kindly see, Your Lordship.
So you file an affidavit in opposition
Lordship,
to the Section 5.
Lordship will do it.
What is the delay? 1,000?
154 days. 1,154 days, Your Lordship.
This appeal is accompanied by an application under Section 5 of the Limitation Act, where the delay is of 1,154 days.
Lordship, yes.
We permit the respondent state to file an affidavit in opposition
Lordship.
to the grounds made out in the petition. Affidavit in opposition by September. Affidavit in reply by 15th September. List the appeal and the application on 17th September.
Highly apply, Your Lordship.
Lodge, Your Lordship.
Number 7.
From here.
Please, Lordship. This is an application for condition of delay of 11 days, my lord.
11 days
11 days.
in preferring a writ appeal.
Illegally appeal against the order of the London Single Bench, order 02/07/2025 in WPC number 75 of 2025.
Writ appeal
It is appeal, Lordship.
made by a learned single judge of this court.
Lordship. Lordship.
We are condoning the delay, Mr. Chudai.
Lordship, there is also a private respondent, Your Lordship.
Let him be. Have you
Let
served?
Yes, let this notice may be issued, Lordship. I will let the
No, have you served or not?
Not yet. No, I have not served because they have not filed any copy yet, Lordship.
So far,
No.
that delay of 11 days, I will not have objection, Your Lordship, but only my submission is that there is the private respondent may have the objection, Your Lordship. I do not.
The court has the power
Lordship, yes, certainly.
to
Your
admit an appeal without the respondent. All right.
Yes.
But when a caveat is filed, notices without notice
Yes.
is mandatory.
Yes.
But here it is not admission of your appeal.
Yes, Lordship.
It is for condonation of delay,
Lordship.
which is some kind of a right which has vested in the respondent.
Lordship.
So he has to be served.
Yes, I will.
That-
I undertake, Lordship. I will serve the notice, but then the previous advocate, whether they will appear or not, but then otherwise we'll send it personally to
You send him, we will keep it next week.
Lordship.
List this appeal and application on 26th.
Lordship.
Full stop. Advocate on record for the appellant will cause service of the papers on the respondent number.
Respondent number is 1 and 2. Number 1, 2.
No, I'm there.
So you're not there. 6, 1, 2, 6.
Respondent number 5, Your Lordship.
On the respondent number 5. And affirm and file an affidavit of service
Yes.
by the returnable date. The other respondents are represented by
Lordship.
Mr. July, learned Additional Advocate General. Yes,
Apply, Your Lordship.
Number 8.
Yes, Lordship.
yes. Yes, Mr. Advocate General.
Yes, my lord, this matter, my lord, the appellant has preferred SLP against interim order of your lordship, directing the appellant to implead the Darbar as a party, my lord. The appellant has not taken steps to implead. As such, there is no stay of the order of this honorable court, my lord. My friend can implead Darbar as a party in terms of your lordship's order, my lord. The steps
But,
are required.
Has the Supreme Court been able to take up the matter?
No, my lord, matter is still pending.
So
Matter is
since
still
it has been adjourned from time to time, we are further adjourning it.
Yes, my lord.
So further adjourned till 12th September.
Grateful, my lord.
As mentioned in our orders, all the orders will be mentioned, and
Yes,
15 July 2025 will be added. Last
grateful, my
call.
lord.
Number 9.
Yes.
1 minute, please. You are ready to go on with this matter?
Yes, Lordship.
All right. Short pass over. You call the next matter.
Number 10.
Who's in item 10?
Number 10.
Some time, my lord.
Lordship, I have a humble prayer, Lordship. Some new document has come to the.
This is regarding that
Weighbridge,
Weighbridge.
Yes,
a
my
new
lord.
document has been received by the petitioner by way of RTI. I may be permitted to bring that on record by way of an
What is
affidavit.
what do you propose to prove by those documents?
Lordship, in the RTI application, we had prayed that we may be provided with the list of trucks which have passed a particular weighbridge. But they are saying that there is no record being maintained with regard to that, what vehicles are being passed and what is it. So it clearly establishes that that particular weighbridge is not functioning in a proper manner, which has been admitted in the RTI, stating that we have not maintained the record of the trucks which have passed the weighbridge.
Which weighbridge is this?
It's the Porlakait.
Huh?
Porlakait. Nongstoin and Porlakait area.
How many
Lord
total
has
weighbridges are there?
permitted
Lordship, the stand of the
around 20, my lord. Around 20
Lordship,
to
the stand
25
of the
and 10 to
state,
20.
the stand of the state government with regard to the number of weighbridges all throughout has been changing. In the previous PIL, it was told 19 at one opportunity. On the second occasion, it was told 24. And this time, when the list has been prepared with regard to the inspection, it has been mentioned 29. So every time the number keeps on changing.
The
You're saying
issue is,
20.
my lord,
You're
no, my
saying
lord,
20.
issue is, my lord, no, my lord, the precise number, what has happened, my lord, that these are the way bridges which are operating under the licenses, my lord. So those licenses, if the license is over, so then that way bridge stops running, my lord. So therefore, there is some change in the number, time to time, depending upon licenses, my lord. Whole case of the PIL petitioner before your lordship was that the comprehensive mining plan, etc., if your lordship will see, initially because of comprehensive mining plan, etc., way bridges are required to be established. That when we placed everything, including comprehensive mining plan and way bridges, then in rejoinder, the PIL petitioner refers to some CAG report of 2012-13, my lord. After that, your lordship directed the PIL petitioner to inspect the way bridges along with the state officials in Garo Hills, in Gentia Hills and Khase Hills. Inspection was carried out by the petitioner and the state respondent for Garo Hills. Khasi and Gentia Hills, he refused to carry out the inspection of the way bridges. Thereafter,
Let her file an affidavit.
yes, madam. I have no issue.
This is the public interest litigation complaining of alleged illegal activities of government officials in collusion with cargo operators in operating the way bridges. Full stop. From time to time, this public interest litigation has been heard, where the stand of the government has been very firm and consistent that there is no violation of any law in the operation of way bridges. Today, Ms. Agarwal, appearing for the petitioner, seeks leave of this court to file a supplementary affidavit. Full stop. She submits that this supplementary affidavit has been prepared on the basis of information received on an application under the Right to Information Act. Full stop. It relates to the Weybridge Act. Give the name.
Longstein.
Full stop. She says that the document reveals that there are no checks and balances in the operation of that Weybridge, comma, and no records of any goods movement, goods vehicle movement. Is maintained. Also, Learned Advocate General. Now, we'll put this out. Leave is given to the petitioner to file a supplementary affidavit by 28th August.
Lodge.
28.
Lodge.
Learned Advocate General denies this assertion. Full stop. Prima facie, he submits, comma, subject to filing a detailed rejoinder that these Weybridges are run by granting license. Also, whenever a license expires, the Weybridge becomes non-functional. Full stop. This would not suggest that any goods carrier is allowed to pass by the government officials in breach of law. Full stop. Such rejoinder affidavit may be filed by the state by 10 September. List is public interest litigation on 16 September. All right?
Deeply obliged.
Number 11. This matter, my lord, I'm praying for some accommodation, my lord. My lord, may fix it next week, my lord.
Lordship may have it after 10 days, my lord. Next week I am slightly held up in presidential reference hearing, my lord. After 10.
Can it be, my lord, on 21st, my lord?
This,
Subject.
my lord,
21st,
we are having
this week, my lord.
difficulties because the hearing of the Supreme Court matter will start from 19 till 27, my lord.
Learned Advocate General.
My lord, my lord.
3rd September we are keeping it.
Obliged, my lord.
By consent of learned counsel for the parties, this appeal is adjourned till 3rd September.
Wait for me, lord.
Yes, call the last matter.
Number 12. Yes.
This matter also, my lordship,
This
may have
Starlight
it-
matter, my lord.
This
Yes,
matter
sir.
also, your lordship may have it on 3rd September, my lord, because it will require some detailed hearing.
My lord, we humbly request, my lord, pray on maybe on 21st, my lord, as per the instruction I've received from the senior counsel, my lord. This matter is urgently required hearing, my
Who's the
lord.
senior counsel?
Mr. Paul, my lord. K. Paul.
My lord, in the previous matter also, Mr. Paul was there, my lord. Mr. Paul is there. my lord.
Advocate General has difficulty.
My lord, then on 22nd, my lord, the
No,
next
because
week.
this whole
Keep
week
it.
is whole week I am held up, my lord. 3rd September, your lordship may have it.
My lord, on 28th, then, my lord, 28th. 28th, my lord.
28th, would you be free?
Your lordship, I would try, my lord, 28th. I am some difficulty until 28th, my lord. I was
All
requesting my
right,
friend.
then we'll keep it on 29th,
Yes, my lord. 29th.
29th.
or if you like, 1st of September, Monday.
1st September, your lordship. 1st September will be. 1st September.
My lord, 29 would be better, my lord.
Considering
My
the
lord, yes, my lord.
considering the convenience
My lord,
of
right.
learned
1st
counsel for
September
the
would be
parties,
better.
this appeal is fixed on 1st September.
My lord.
Grateful.
Highly obliged.
Yes. Call the first one.
Second call, item number 9.
I'll not take much time. I'll just place the dates. Your Lordship has already looked into the dates. But on the last occasion, we have given the list of dates. Madam, there's a one. Is there in the record? A single sheet of paper with.
This one?
Yes.
Just check it up for one because more than one list has come.
Yes, ma'am. Yeah. No, we have provided the second set also, 2 sets. We have an extra copy also. If it's required, we can give it. Is there? Thank you. Now, your Lordship will kindly see the first date, 18/1/2011. There is no dispute on this date that it is the date on which the cause of action arises because it was the date of termination of the contract. Now, the second date is the 22/8/2011. This was the day on which the status quo order was passed by the trial court. That is, this status quo order was passed from 18/1/2011 till 22/8/2011. There is a 216 days. Then this status quo order was vacated on 7/3/2018. That means after 6 years, 6 months and 16 days, that is 389 days, which is to be excluded in terms of Section 15 of the Limitation Act, which your Lordship has already pointed it out. Now, if your Lordship takes from 7/3/2021, the 3 years period, that 3 years period from the vacation of status quo order ended on 7/3/2021. Your Lordship got it?
Yes.
Then from 7/3/2021, since initially we have 216 days in our account, then if you minus that 216 days, then this should ought to have been filed on 5/8/2020. Because the status quo order was passed after 216 days. So they had that time to file that suit within that. So if you minus that 216 days, then it is 5/8/2020. Now, COVID started on 15/3/2020, the next day, and it ended on 2022. So the COVID period, entire COVID period is of 716 days.
Yes.
Now, your Lordship will see the next note. In terms of the Supreme Court order dated 10/1/2022, in the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. In this case, the limitation period expired on 5/8/2022, which is within the COVID period. Therefore, the period from 15/3/2022 to 5/8/22, that is 4 months and 21 days. Here they will get more than 90 days, that is 4 months and 21 days. That is 144 days has to be added to 1/3/2022. So now the new date of filing of the suit will be 23/7/22. Now your Lordship will see.
1 minute. Supreme Court order?
Supreme Court order is of 10/1/2022. Your Lordship can look into that.
Later, that longer period will apply.
Yes, madam. My learned friend was saying that I'll get 90 days. I'm giving him more because the Supreme Court order says that 4 months. It is filing में this date is भूल है 16/8/2020 now.
Yes.
Now your Lordship will find there is slightly a typographical mistake. This is not 16/8/20, it is 16/8/2022.
Yes.
It ought to have been 16/8/2022. Just I'm correct. Now 16/8/22, they ought to have filed their suit on 23/7/2022. They filed the pre-mediation application on 16/8/2022. That is after 24 days. From 23/7 to 16/8/2022, they have filed a pre-mediation petition for after 24 days. Now the mediation concluded with non-stata report on 16/1/2023. That's the next date. Your Lordship got it, my lord?
No, what is the allowance given for pre-mediation litigation?
This from 16/8/2022 up to 21/2023, they will have this period for pre-mediation litigation.
From 16/8.
Yes, my lord. 16/8/2022 to 21/2023. That will not be taken into account. But they delayed because the suit house ought to have been filed on 23/7/2022 after the Supreme Court order. Here also there is a delay of 24 days in filing the pre-mediation litigation.
No, then it's gone.
Yes.
24th July, they are gone.
Yes, yes. Now your Lordship will see, they filed a suit on this report of the mediation was received by the FCI on 21/2023. That is where the mediation period ends. Then they ultimately filed a suit on 21/3/2023. That is after 60 days.
If it is gone on 23rd July,
yes, madam.
No exclusion is relevant. Nothing to be excluded.
But even I am telling that even if this mediation period is excluded also, then also, my lord,
it cannot be.
Yes,
it is excluded.
cannot.
23rd. This is not an application.
Yes, madam.
23rd July.
Yes.
So the moment.
In terms of Section 3, it extinguishes there.
Yes.
Of the Limitation Act.
There no more exclusion
Yes.
minus 5%.
Yes. Yes. Now your Lordship will only see what the learned session judge has.
We will go through it. You file your notes.
Yes.
This is most material.
Yes.
Would you like to add something?
Yes, I have got a reply to that, Your Lordship. Because I have heard, Lordship, Your Lordship also heard, my learned senior friend has submitted. From the very beginning, I am submitting before this Honorable Court that under Article 54, 55, I have got 3 months period to file a suit for realization of the loss the FCI would have sustained. Now what happened, Lordship, if I am allowed just to pass over my submission, a reply.
Yes, yes. Why don't you file notes?
Pardon?
Written notes, wrritten submissions.
Yes, it is a written submission, Lordship.
All right.
I shall try to. আপনারও কপি এখন আছে কোয়েঙ্গে इसको কপি वो इसको ज्यादा आ गया और there is for respondents copy. Lordship, I try to make it in a very accounting method. I first gone in the right side, my right to file case. Kindly see in the right side, right to file between 18/1/2011 to 17/1/2014 as per the provision of Article 55 of the Limitation Act, being 3 years from the date when the cause of action arose on 18/1/2011 when the contract was terminated. Here I am showing 1,095 days. Second, I am submitting, the respondent filed a civil suit before the Court of Assistant to the Deputy Commissioner, Judicial, Shillong, and took interim relief as status quo from 22nd/8/2011, continued with effect from 29/8/2011 until the status quo was vacated after 6 years, 6 months, 8 days, that is 2,385 days, by the order dated 7/3/2018. Now, next phase of 3 years limitation under the provision of Section 15 of the Limitation Act 1963. The fresh cause of action arose from 8/3/2018 for 3 years ending by 7/3/2021. The date of order is excluded. Here again, 1,095. Now, in a very shortcut way, I am trying to, I'm endeavoring the plaintiff should have filed the suit public case on or before 7/3/2021 as above stated, but could file on 21/3/2023. Now, suit was filed on 21/3/2023, but should have filed on 7/3/2021. So there is a delay of 2 years, 14 days, Lordship. Now, I made the analysis here below. Exclusion period of 806 days is equal to 2 years, 2 months, and 16 days, but the suit was filed after a lapse of 2 years, 14 days. So the last position is as calculated below. Exclusion period is 2 years, 2 months, 16 days. Delay is 2 years, 14 days. So 2 months, 4 days ahead the suit was filed. This is my calculation. Now, before I go to the second phase of my submission, I beg to submit, from where this provision my learned senior friend has placed before your Lordship, that the 216 days I am to give up. I have not understood, because my right to file the case is 3 years. I can file the case at any time before the 3 years is completed. On the first occasion, your Lordship, I do remember, Lordship was...
How are you dealing with this chart which they have handed up to the court? What is your answer to this?
My answer is that the findings given by or the calculations done by is not backed by any law.
Means? How?
Not backed by any law.
Means?
Now, question is that, suppose Lordship on that day was pleased to ask me that 216 days what your corporation has done. My submission on that day was that the contract was terminated on 18/1/2011. At that moment of time, the corporation could not assess the total loss. Here the question is that a ad hoc contractor will be appointed, and if there is any difference between the rate, that will be realized from the failing contractor. Now, after the gap of 3 months, we have given our first bill that you give it. Then he did not give it. Then we send the second phase. When we send the second phase, Lordship, he came to the court. He came to the court and restrained us from making any further assessment of loss, because our loss is going term by term.
Till
the contract is period of 2 years with him is over. That is my submission, Lordship.
In your plaint,
yes, Lordship,
you have stated the accrual of the cause of action as 18/1/2011.
Yes, I have taken.
Not at any later point of time.
I have not gone, because in the case I have found, and otherwise, when they have come and restrained me, then my cause of action starts.
If you had taken at a later point of time, then we could have understood. The time also would have been stretched. But you have taken it from it. That is.
I have taken because that I'm just explaining
right
your Lordship the actual position, what happened here.
No, actual position is not relevant. We have to go by the dates, exact dates.
All right, I have gone by. I have gone by.
You file your notes. We will go into it. Please take down. Hearing concluded.
So, rest of the matter, Lordship,
No, there is no rest. Finished today. No rest.
No, I have met the other points.
What other point? Only limitation is involved.
No, other points are there.
What?
That the learned trial court below has made a mistake again. That one is to be calculated, Lordship.
What? It is only on the point of limitation, nothing else. Only limitation.
Yes, while calculating, that mistake has occurred.
We will calculate.
Kindly see, Lordship,
No, please don't delay this matter, dilate this matter. We have gone through it. We can understand your position, Food Corporation of India, it's all right.
Much obliged, Lordship. But I have given my...
You have done the best you have can. We have received your notes, we have received his notes.
Kindly go through,
let us do what we can do, then the Supreme Court is there for you. And for him also if he loses. We are not, we are free.
Yes, sir.
Yes, hearing concluded, CAB, learned. You have submitted this chart, you are not furnishing any notes.
No, it's simple. Your Lordship has already pointed out that the exclusion of that under section 15, then section 3. Only two sections are involved.
We have concluded. Learned advocate for the appellant has handed up to this court written submissions which we have taken on record. Learned advocate for the respondents does not wish to file any written notes. Also.
We are deeply obliged, Your Lordship.
Much obliged.